you think? I can't hear you. You'll have to unmute yourself.
There we go.
Yes, much better.
Okay.
So Ana, thank you. Yeah, so thank you very much for being part of the symposium. And of course, you'll have to tell us a little bit about yourself. Then I will talk a little bit about the symposium, and then we'll go into mediation legislation. So please, Ana.
All right. Well, a little bit about me. I am family mediator for the most part, but I do practice corporate mediation and real estate mediation. I do have my own practice. I am in the state of Utah in the United States, and I'm a Spanish speaker. So I was originally born in Mexico, but I have been here for 37 years. And as a mediator, I think it is a very important thing to have the awareness. And I am really happy to be speaking with you this morning, your evening, my morning. And well, in my mediation practice, I have introduced marital mediation as an alternative to a divorce mediation. I usually talk about it in my opening statement for parties to have that as an option if the divorce decision was taken on a whim and very fast. This gives them the opportunity to resolve those issues and save their marriage. So that's something that I like to do in my practice, and marital mediation has become very effective. I mean, I don't want to say that I'm saving a lot of marriages, but I do save at least 1 or 2% of those that want to get divorced. So it's something that I do, and I'm promoting it. I'm also a speaker on educating marriages on what it takes to be happy in your marriage. And so I think it is my duty, after divorcing so many people, to help people to stay married. And I do that in the United States and in Mexico. I decided that if I was going to divorce people, I was going to emphasize that being conscious and respectful to each other was the best way of the beginning of a new chapter in your life. So part of my memorandum of understanding has a parenting advice to parents that are going to be divorced, because divorce is eternal. And so I believe that for the most part, mediation, it is self-governing. But what I want to say, that a little legislation it is for mediation is quite magnificent and important. Like Agni was mentioning, there is a need for that legislation. In my point of view, as I practice over 13 years as a mediator, I've noticed that if there is a little bit of legislation, like you say, turning into what the colonization did and having things to do in the law, and everything is litigation, I believe that we need a little bit of it. And I can explain a little further after you. I think you want a few minutes to introduce the symposium.
Yeah, basically just that 30 seconds. I've stopped taking people through my website now, because it's better they just have a look at it instead of repeating it. So this is what we're doing: mediation legislation. How, what, when, where, which, who, why, and any other questions you want to add to it. Not a problem, but let's just question everything, because look, the idea finally is that we have to look at development of mediation. So however people have experienced as legislation been good, bad, ugly, whatever. So let's have a look at that also. And now, of course, we have 50 speakers from 30 countries. And I'm okay with more people coming in, I think, because it's an interesting and an important discussion. So let's see, maybe I'll extend the symposium. So that part of it is that, yes, of course, information about work, but Ana, if you have to find information about what I'm doing, where would you go? How will you find information about the whatever events and all that I do? How will you find that information?
Well, I've been following you for a few months, and I just look for your last name, and I look for you on YouTube, and I look for Mediation, Mediator.
Look,
And
one option, yeah. One option you do have, you can go to mediatorvikram.com. I try and put down whatever's coming up and all. So that I have this section there, which is like, I mean, of course, I mean, this all obviously keeps getting updated. And sometimes I don't normally am not late, but I do update it. And you would get to know about the World Mediation Circle and things like that. So the various other things, what happened last year, what happened before that. So all that information is there. So you can definitely go there. But should I write Mexico also against your name? You want, can it be Mexico and USA, or do you just want to say USA?
I would say Mexico and the US, because as a Mexican born, I really would like to have that awareness in Mexico. And so I am working, and I'm working with some mediators in Mexico to bring awareness to our culture. And I will be interviewing people, kind of like what you're doing, to bring awareness and to post in, several settings, so that people could say, oh, I've never heard of that. Somebody called me the other day and said, I see your post and you say that you're a mediator. I think to divorce or help marriages, I think the right word should be psychologist. And I go, wait a minute. I am not a psychologist, I'm a mediator. And so she was thinking that I was talking to the spirits and all of that. So there is a lack of knowledge. In Spanish, there is a word, that mediator is also somebody that talks to the spirits. And so
Mediator. That's interesting.
So it is one of those cultural things that to educate, to bring awareness, what really mediation is all about, and so yes, I think Mexico and the US is right now my goal.
But I think interesting thing that you said about your wanting to get, people to get together, maybe not divorce, and in whatever way helping them for the marriage to continue. I'm just thinking what has happened really is, and in a lot of countries, that social structures kind of broke down, and there weren't those people in families available for people to talk to, which was a cultural thing, which I'm sure Mexico also, maybe in families and all, there were those people. So maybe that is also a role that mediators will play or are playing, that they're available as a think of it as a family member. You don't have anyone to call, but you have this person who's outside, but to treat that person the same way you would have done if you had somebody, say, an elder in the family that you would have gone to. So you look at it from that perspective, you think something there?
Yeah, and I think it is, I am older than most people that come to see me, and I'm like a grandma or a mother, and I let them know that, hey, like you say, the institution of marriage is so important for a country, for a culture, that if we could save or we could tell or teach how to communicate using the mediation process, is what I teach my couples, using the mediation process to learn to understand and not to just respond. And I'll teach them also several skills that a lot of people get married and don't know the skills of being married, like frugality and, in the finances and even intimacy. And so it is very important for me to introduce marital mediation to couples that come to get divorced, because there's children involved most of the time. And so for me, the family is a very important.
Well, there was a symposium I did 2 years back, which was Mediation in a Culture and Traditions, which we had. I've had 97 speakers from 45 countries. I have to throw that also in. So there was someone from Morocco who was saying that in the cities there, divorce rates are really high. And he was saying it is because that whole family structure has broken down. People have moved into the cities and now they don't have anyone whom they go to. So divorce rates have gone up for that. So that's why I'm saying I think a mediator has a much larger role to play in society and in communities, which is what I'm trying to create through the World Mediation Circle. But of course, this discussion, of course, is an important discussion. But Anna, mediation legislation.
Okay. Well, I am not going to put a presentation like other people. I really just want to talk about it, because I think mediation legislation it's very important. in the percentage of what we have in the mediation of the legislation, I think that's where I see a problem. If there's too much legislation, then there's a problem. And I can explain to you a little further how I see it in Utah and other states here in the United States, and how I see it in Mexico. Now that I spent the whole month of February talking to mediators in Mexico. And, you know, I really believe that there has to be some transition from, litigation to mediation. There has to be some transition of awareness, of also in the law saying, you know what, we suggest that you go to mediation to handle this. Wait a minute, what is mediation? Well, they will explain to you. So in the state of Utah, for example, for divorce mediation, if there is a contested divorce, the court's required that you go to mediation. There is established a mandatory domestic mediation program to help reduce the time and tensions associated with obtaining a divorce. So if after the filing of an answer to a complaint of a divorce, there are any contested issues that they don't agree, they go to court, and immediately the judge will tell them, you need to go to mediation and participate in good faith in at least one session. That is the requirement, one session. And I think from my perspective as a mediator and with my private practice, I can tell you that has helped a lot of marriages resolve their issues a lot faster, because in the court system, it takes for a long time. And so people have noticed that mediation is a way to finish up their divorce much faster and maybe even cheaper and less stressful. So that mandatory domestic mediation program that we have in Utah has been, I think, very, very good to promote mediation, because if there was not that requirement, I would think that mediation would not have come up as well as it has in the last years. For example, right now, people that they're getting divorced, they call a mediator. They don't go to court first. They call a mediator first. They do their divorce with me or with another mediator. Then they fill up, they file it on the web with the court system. Especially after the pandemic, that became a very viable alternative to just come to a mediator via Zoom, fill their information online, and file their divorce while they were in their homes because of the pandemic. So that has had a transformation of how we do mediation in the United States, and specifically in Utah, where I know how it is. A lot of attorneys and a lot of mediators, we spend more time on Zoom than with people in our offices. So mediation has a very high success rate. In Utah, we have about 86% of the cases are settled. So it is a very good way of looking at, how is mediation doing? And it actually does much better than the litigation. So as a mediator, my goal is to help both parties resolve their conflict and guide them and make it easier, this process of whatever they're going through, especially in my practice that is mostly divorces. And so I take them and then separately in Zoom, you can put them in separate rooms, ask them about their problem and separate their emotions from their problem, and then focus the interests and not positions, and create a variety of possibilities before negotiating. And so when you focus on those objectives, people, like Agnes was saying, they will tell other people, well, why don't you go to mediation instead of going to court and litigate your case? And so, it is my opinion that a little litigation is good to implement mediation in a society where litigation is a norm. But we need to be careful because it can be over legislated. And if we let it, then it takes us away that magnificent result of the mediation process. So letting the mediation process of collaboration and reconciliations go to its regular course, take its course of understanding and settling on an agreement, the result of the parties and including the mediator, it is a more successful way of resolving conflict. And I think the awareness that we can bring to other people to say, you know what, mediation is probably the future in resolving disputes. I see it as the future of it. Also, if we think of the cost of the state court system, this is a significant savings on their budget. And I also see it in real estate mediations when I do mediations, even though it's not legislated. It is only a contractual law, in their contracts as a choice for a buyer or a seller to use mediation as an alternative instead of going to court. I think is great, even though it's not legislated. People are putting it in their contracts. I mean, the state puts it in their contracts for buying or selling properties, and is helping in the cost for everybody. So overall, leaving mediation as a self-governing process gives us so much to every state and country where it's practiced. And I think after staying in Mexico for a whole month, I feel stronger about the self-governing process of mediation because of what I saw there. And I know that there are some countries where you need to be a lawyer to be able to practice as a mediator, which is what I saw in Mexico. And many times mediation is not a career that fits all attorneys. Some lawyers have a tough time switching that hat, from being in litigation to being a mediator, a neutral party. So mediation is not for everyone. I understand that, especially not for every lawyer. But I see it in other countries that mediators have to have a law degree. And to me, I think it needs to be open to a lot of people that are not attorneys, that have that gift, that have that, is just in their personality, that they do well. There's some psychologists, there's social workers, there's family therapists. Any person with that gift in their personality for resolving conflicts will have the right and the opportunity to take the course and mediate disputes. So I think sometimes legislation can be too rigid in other countries to say, you know what, if you don't have a law degree, you could not be a mediator. And I have seen it in Mexico. I have seen it in some countries in South America where I have some contacts that, they're requiring it, and it's not necessary. I mean, to be a mediator, you don't need to be a lawyer. And anyways, in countries that we were founded and they're really rooted in legislation, the mediation process and the mediation practice will have to take its needed process of acceptance and understanding. I mean, I see it in the US, it's taking its, slow process of understanding, but all the states of the United States use mediation. And mediation is used in corporate. It was very interesting. The other day, somebody found me in LinkedIn and wanted me to hire me for a company to be a customer service for this company. They are looking for mediators instead of just giving the job for another person that just wants a job, an entry-level job. Of course, I did not apply for that company, but they are seeing the actual plus and the wonderful training that is done in mediation to resolve conflicts from the minimum to the big, processes, or the big disputes, the small disputes. So mediation, in my opinion, is the future of resolving conflicts between countries. You know, when we see a war, I think mediations and mediators need to be involved more than anybody else, or any litigation. You know, corporations, communities, in neighborhoods and families and divorces. This process is going to become the norm on resolving conflicts, and that is my hope. You know, I usually hear that when I go to visit other countries in Mexico and South America, when I talk to them, that they say, well, we didn't know about this. You know, when I got divorced, the first thing I thought is, I'm going to call my attorney. I know him. He is my friend, and I'm going to call him to help us with our divorce. But I never thought of mediation. It never even crossed my mind. So this awareness, and the reason that I contacted you is I really would like to have another sentence in their, in their thinking when they have a conflict, when they want to get a divorce, when they have a problem in their company, when there's discrimination, when there's anything that causes conflict. Instead of saying, well, I'm going to contact my attorney, I'm done with you. I'm done with this problem. I'm just going to call my attorney and he will contact you. I don't want to talk to you anymore. That's what we usually say, or what we used to say in our societies. And so I would love for people in Utah and in the US and in Mexico to be able to say, you know what? I don't like this conflict. I am going to look for a few mediators and send you a list of several mediators, and you can choose, and we can come up with one that we like, both of us like. So
that's the objective. That's the objective. What I'm trying to do. That's the objective. That first of all, the fact that this is a process that you connect to. It's not some technical problem issue. Some rocket science is coming to you, which is why legislation is being spoken about, because the court system, there is legislation. In the US, there is legislation. Then there is, of course, mediation outside the court system where there is no legislation, maybe where there might be something you'll tell us about that. But the fact is that, has that really worked? You said maybe it's a good thing, a little bit is a good thing that people are pushed towards mediation. Maybe they go there and maybe it'll be good for them. But over these years, because it's been there for so many years, has that really worked towards people really saying that let's call the mediator first, or it's still a pathway to mediation is still through the court system? I mean, has that really helped in the larger development and promotion and awareness of mediation at the grassroots level? And has mediation been connected in a good way in people's mind rather than a negative connotation in relation to the court system? So those aspects you have to tell us about.
The last part that you mentioned, that, the negativeness that some people put into mediation, to say, you know what, mediation is just not going to go anywhere. Let's just go to court. That negative connotation to mediation, I think it hurts quite a bit of mediation. And I think it is more from the legislative. It could be more from the community of litigation towards a mediation than anything. And I think that is probably the worst part of having the litigation and mediation, because people feel that is not going to carry through, that is not going to be solved, that nobody is going to be forced to commit to a certain resolution. The mediators were too nice, that we are not going to help anybody really come to a resolution. And so I have had very, very hard cases where they go, oh my goodness, I never thought that coming to you, we were going to come to an agreement, because it was just such a big mess that we've been going to court for the last 3 years, and we have not come to a resolution. But nobody told us that a mediation would be any better than litigation. And so I think you're right on that note that, that connotation of mediation not being as successful or not being as good as litigation. I think it is something that culturally we need to change. We really need to bring the awareness of saying, you know what, really big problems can be solved in mediation much better than in litigation. And so, because there is that collaboration that it does not exist in litigation.
Well, I just think from the perspective that 50 years of mediation in the court system in the US, and today also, the first aspect when you have a dispute, you don't call a mediator, you're still going through the same pathway. So it's a good example to see whether legislation in relation to mediation, does it really work? Of course, in the structure of the court system, because I just see it as a situation that's happened where lawyers have taken control over mediation. So it's really not the way mediation should be. To really call it mediation itself, is that the right thing at all? So your thoughts on that? Yeah.
Yes, and that's why I think when you're saying about lawyers taking that control, I think it is a very true. And I think mediation will lose its marvelous way of doing it when litigation is not in the way. when legislation is not in the way. I totally agree with you, because I see it talking with mediators in Mexico. Private mediation is non-existent for many of the states. There's very few states in Mexico that are practicing private mediation. And because there's over legislation on mediation, which it shouldn't be, because it doesn't serve its purpose of mediation. So yes, I think we are over legislated, and you're right. The attorneys put a little bit of a cover up on mediation and saying that, no, we shouldn't do that.
Yeah, because I think the first thing itself, of course, let me just go back to what you said about mediation is the future. In my posts, I used to put out there, mediation is the future of dispute resolution, and the future is here. So the important thing, Anna, is that really in relation to the understanding of mediation by itself, what is mediation for people? Are there different perceptions of mediation itself? Well, like I said, in the court system, lawyers taking control, are these really settlement conferences, or would you call this mediation? I don't know how people are looking at mediation itself. So that then when you want to legislate, what are you legislating? First of all, what do you understand by mediation itself? I think, is there some common understanding of mediation?
Yeah, I think all that I know more is in Utah. And I think when you have something that is believed to be a mediation, but it really is not. What I see in mediation, when I mediate a case of a divorced couple and they have their attorneys, in my experience, some attorneys let me mediate, and some attorneys want to speak and mediate with me instead of their people that they represent. And so I don't think it serves its purpose, because you're mediating there with the couple. They can consult their attorney, but the attorney cannot speak for their client in that sense, and so I totally agree that the over lawyers can be overprotective and overbearing on mediation, and it doesn't serve the purpose.
Yeah, they still consider it their process, because they feel dispute resolution is their domain, and everything related to that, they have to get involved in it. So which is what I've been trying to put out there, that look, lawyers might be experts in the law. They can be brought in when you need an expert in law. Similarly, in certain other disputes, you have a project, you need an architect or a civil engineer as an expert, you can bring them in. So this understanding of mediation itself, I think, needs to change. This whole colonial aspect of no, this is not something where you have to go to a lawyer or you have to have a lawyer involved. So that mindset itself has to change. I think when you have to really take mediation as I understand it, and I think you also understand mediation, to take that forward. Yes, there will be this kind of thing which will be called mediation, but is it really mediation itself? That also I think needs to be really looked at, because I think that is where things are going wrong. Because if there was so much experience in relation to mediation in the court system and everyone had something good to say about it, there would be so much good word going around about mediation that people will say, oh yes, forget the court, forget the lawyers, and you have a dispute, call this mediator. I don't think that's happening in the US in so many years of mediation being there in the court system. So I think there's something, someone has to look at the basic fundamental thing, that what are people going back as in relation to their experience with mediation? Because I keep saying this, I mean, this is what I say, that you've gone into the court system and the time and money is the factor for which you think, okay, let me settle it because it's going to take so much time, or so it cost me so much. So one is the inefficiencies of the judiciary are one of the reason why you want to maybe just say, okay, I'll settle, but you don't really want to settle, but there's a gun on your head, which is the time and the cost. So that really will not be, for me, really the mediation the way I would want to promote it, because you will not come out happy saying, oh, I settled because I am happy with what I did. It's because I was forced to settle because the other option on the other side was very costly and time consuming. So in that kind of a scenario, to really be able to get that good word out. So how do you see that good word out? Because up till the good word is not out there, people are not saying good things about it, their experiences. Up till then, how do you really develop it? And I don't know, maybe I've gone away from legislation a little bit, but why it's connected is because that other process, and if you have to create the good word, what is the kind of legislation you need for that? And if any legislation is required. So please.
I think a little bit, like I was saying, a little bit of legislation to promote mediation is good. Other than that, I don't think legislation should be in mediation at all. You know, I don't think it should. And the way that I think bring awareness to mediation is, I mean, I can tell you what I am doing, because I see people that are immigrants in Utah from Mexico, from other countries, that have no understanding of the legislation or the law in the United States. So I think promoting mediation to settle the disputes in a private way and bring awareness by going to places and, in a way, advertising that it works. And I think that the best advertising for me is when I get people that come to a divorce pro se. When they come pro se, it's a beautiful thing, because we can actually really do a mediation well. And when they go in and meet somebody that wants to get a divorce or settle on some neighborhood problems, they come to me because they said, well, that was magnificent. You know, I did not have to go to court and we settle. So I think there's a lot of work to do as mediators, but I think we need to get it promoted. I guess that's what I want to say the most. We need to promote. We need to take the stand and promote mediation for the goodness of this world. I think there's a lot of need to promote and to bring awareness.
But when you said that, okay, there should be some basic legislation, what would you want in that legislation?
I think in the basic legislation that I would like is that the court system or the legislation would promote mediation as an alternative for people to change their frame of mind. I think, to me, that's all that is needed. To say, you know what, you have known this way of litigation to solve disputes. This is another way that it is correct. And so a lot of people look at, you know, the laws and look at what the government says for approval, that it's okay. That is not a person looking at the spirits telling you what's your future. And so I think it is important in that perspective to do a bridge, to do a bridge of saying, yeah, we as a government say, yes, go from here to here. And like Agni was saying before I start talking, that in Lithuania, in the government, they do impulse and they promote it. The same thing in Mexico and the same thing here. You have mediators in the court system. But I think the legislation promoting mediation would be a great, that's all that's needed. I don't think legislation should get in the way. And I think mediation should stay as a mediation without lawyers involved.
Well, what has happened really with mediation being connected with the court system is because one, of course, it's connected with the court system. That by itself is not a good thing. The other thing is that free concept, that this is kind of free or maybe very nominal. So the value, I mean, you really value something, which was what Agne was also saying about, you don't value free things. So that way you are in a way, are you demeaning the mediation itself in people's minds? So that's one thing. But what I was, in terms of basic legislation, in the post that I put out the link, I put the link to the Indian legislation. And I keep saying that that's how basic you need. What do you want? You want confidentiality protected. You want it to be without prejudice. And you don't want a mediator to be called in as a witness. And everything else should be what the parties decide. I call them participants because I think, like we discussed, it comes from the court system. This whole parties word, very adversarial. So call them participants. So if that is how basic it should be, I mean, I look at it that way. I don't know what your thoughts on that are, that you can appoint whom you want. Process is, of course, as flexible it has to. And you have a choice. You want the mediator to suggest, your wish. You don't want the mediator to suggest, is your wish. It's not something, because I'm telling you what has happened is that you have these these schools of thought on models that have come up: facilitative, evaluative, transformative, and the user is confused. I think the user doesn't know what you're talking about. They're not even interested in that theory. That's your theory. For the user, let's keep it simple. Because up till the user doesn't think it's a simple process, they will have to go to a lawyer to understand the legislation. And once you've gone to the lawyer, that's another pathway that you've gone to. So I'm looking at basic legislation. That's why I put that out, that please have a look at that legislation. And then we can discuss it as to what you think needs to be put into that. Because on 19th, when we talk about a workshop, let's just put together something which we think is all that's required. And anything more than that will complicate it for the user. So let's do that.
Yeah, I think you put it just perfectly there when you say mediation is simple. And once the user knows that it's simple and it's easy and it's quick, and even though they pay me on an hourly, basis in a private practice, they're happy to do it. They're happy to do it. Why? Because they know that it's going to cost them a lot more if they go litigating. So if we let them know that time-wise is fast, it's a lot cheaper than litigating, and it's in a peaceful setting and not stressful, people go, oh, why didn't I know of that before 3 years ago when I've been litigating this divorce? So I think, making it and letting them know that simplicity of and then also those three benefits, it makes very attractive. And I think the more we promote it with good results is going to, I'm hoping, is going to get more use,
Because the other thing that I say, that again, coming to the Indian law, that settlement agreement is as good as a court decree. And you don't have to do anything more than that. Just a written settlement agreement signed by the participants and by in this case, they call it conciliation, but I won't get into terminology. Let's call it just mediation. So the mediator signs it, and that's good enough. Because look, first of all, this whole very major focus on enforceability, and that we have to in some way take it into another process of registration and all those things which people talk about. I think there's a lot of focus on that enforcement for no reason, because if the mediation has happened properly, they've settled it on their terms. Let's not even put it into their mind, oh, you'll need enforceability. It's your solution, you worked it out. So I think that also needs to change, because I think that's the very lawyer focused thing. Oh, enforceability, why are you looking at negatives to start with? It's a positive process, a positive outcome has come on it. Why would they go back on it? First of all, why do you put that into people's mind? I think there's this negativity around dispute resolution itself, which has been created by this whole colonial concept of the court system, and of course the lawyers being part of it. I think that needs to go. It's positive. You enter into this on your terms, it's your agreement, it's your solution, and perfect, you will honor it. Why would you not? So I think that little positivity also has to be thrown in.
Yeah. And you know, the memorandum of understanding, which is the paperwork that I write for this divorces, absolutely, I don't sign it. I don't sign it as a mediator. And they take it and get it notarized, and they sign it, because they are the ones that actually came up with that agreement, not me. They did it. It gives them the power to say, this divorce was how I wanted it and how you wanted it, and we signed it. And then they don't even have to get it signed by anybody else. They take the paperwork to the courts and get it legally binding with the courts that they're divorced. So in a way, I think in Utah, it is a good thing. It is a good thing that they don't need me to sign it. They just need to agree that they agree with that document. And I think that has been a really good practice for divorce mediations. So
I think, yeah, well, I mean, that's the best thing, that of course it's their agreement and they're signing it. But only thing is, because they have to take it to court. I mean, that's because they're getting that stamp of approval from there, which is another step. But I'm saying that in those mediations where that is not required, and by itself that document is complete, do you need the signature or not? That by itself can be discussed. Do you need anyone else to sign? This is your settlement. You came to that settlement. It should be good enough. Why do you need anyone else? That's a good point there. So we should look at that, whether that's required or not. But otherwise, I mean, if there's anything else you think in relation to legislation, if that, I mean, you think any point needs to be added or not, because in terms of confidentiality, definitely it's an issue in the US. Confidentiality is an issue because, of course, there is one mediator there who's gone around on a confidentiality tour saying your mediation is not confidential, because of the fact that the courts can ask for information that was in some way part of that mediation in the process in the court. So he says it's not confidential. So for a mediator to even say that, it is malpractice. So that's another side of it. So that's why confidentiality protected by law by itself takes care of that. So that's why, again, I'll go back to that Indian legislation, that all that is on a countrywide basis, your mediation is confidential. And nothing can be called into a court. So that's one aspect that, of course, we have. But I mean, similarly, do you think of anything else that you think needs to be put into it? So please.
You know, I think that you touch right now, I think that is a worrisome. That's something that all mediators we dread, and we're something that we wouldn't like to happen, because in our opening statement and our agreement to mediate with any party, we tell them, we cannot be subpoenaed in court. If not, we have to quash the subpoena. And I think that's where the legislation needs to back off, and not request anybody as a mediator, to be as a witness.
Exactly. That's what I'm saying. That's what these three things that I was talking about: mediator not being called as a witness, and the process being without prejudice, and confidentiality. I mean, these are simple things that you need to protect. Beyond that, do you want to? Do you need to? So, because there is, of course, the other discussion on certifications, trainings, accreditations, which of course I am a big, I do criticize that concept. For me, that I mean, who should be and can be a mediator? I think let's just leave it to the people in dispute. It's their dispute. Let them decide whom they want to bring in, and they can bring in anyone they want. Who are we to restrict that for them? So but that's my thought on that, because I think this comes from the colonial concept of we will decide for you. We know what is best for you. Whom you have to sit with to resolve your dispute, we will tell you. That person has to be endorsed by us. I think that part of it we need to give up on those kinds of that whole mindset, and that's why that legislation which comes from that mindset, I think that's why it becomes over legislated. Because once you start on that track, and because I don't know, with the session before Agnes session with Chitra from India, there was a bill which was put into Parliament, and if you had seen it, it's like complicated, 50,000 things they want to legislate in that. For what reason? Just because we have to make a legislation, so we must get in everything we can into it and overcomplicate it, over legislate, even simple things that we are going to tell you how you will conduct your online mediation. Okay, so everything, every step I take, I have to first go through whether I go through this or not. I think getting a little too, I think, like I said, again, over legislated. And then attempt is there. Whether it works out or not, I'm hoping it doesn't go through, those things don't go through. But when you have, of course, you have certain vested interests also, which would be the same thing in the US, who want to look at certain aspects to be coming through legislation, like training and accreditations. If you have that, and that too for a country like India, if you can have a few people who can control that, you can imagine how big that industry is going to be. So those vested interests also getting into the picture. And of course, the judiciary's self-interest, because they're inefficient, so they're putting it into a certain way. So all those people who actually are not at all really looking at the development of mediation independently and still connecting it to like the court system and all. I think maybe that's why this discussion and this symposium, let's from our side look at it, what are the practical things and what is really required, and let's put it out. I mean, tomorrow if there's a legislation being discussed in the US, you can bring in those thoughts there and put it out there. So that's one of the ideas behind it.
So
So
let me understand and see what you're saying. I don't know. Do you think that mediation should be an entity totally separate from the court system?
absolutely, absolutely. I mean, first of all, even to say the two things in the same sentence is, I think, going against mediation totally.
Yeah.
Like I said, I'm telling you, dispute resolution has to happen in courts, and lawyers have to be part of it. Is the colonial mindset for hundreds of years has been put into people's mind. If you have to break away from it, you have to break mediation totally out of it. There should be no connection at all. No one should think of mediation and a court comes into their mind. It just should not happen. You talk about mediation, a lawyer should not come into your mind. That's when mediation would develop with mediators. When you talk about mediation, a face of a mediator should come. Anna's face should come. People, when they talk about, oh, do you know a mediator? They should be able to tell them about mediator. Oh, do you know a mediator? Oh, I'll ask my lawyer. That whole step has to go away, because
Right.
then I think it's going to happen. And it's not easy because, like I mean, in most countries, maybe all, the judiciary is the most inefficient institution. And their inefficiencies, they want to push away by telling people to go into mediation. That inefficient institutions working now in that mediation is used against the person who might really feel that no, they will get some justice in court, but because justice delayed, justice denied, that justice is going to be denied, so that inefficiency is told to that person that look, it'll take you 10 years, in countries like ours 14 years maybe, and it might take you 14 years, and of course it'll cost you, so why don't you settle? So the inefficiency of the judiciary has sent the person into mediation, and the inefficiency of the judiciary causes that settlement. How is anyone going to go back happy? You want people to to be something that they want to do. They want to work together, collaborate, whatever, understand each other. There are a lot of other factors on the other side. Those are not in play. Something totally different is in play. And it all starts from the inefficiency of the judiciary. I'm saying let there be no mediations. People should not go for me. They don't want to go to mediation. No, if they have faith in the judiciary and they want to stay in that colonial mindset, give them justice in a day, 2 days, 1 week. Maybe that's also long. In certain cases in a criminal system, why should a person be put into a cage which the judiciary or with the government at some point thought, a colonial power thought we should put people in cages? Animals also, if you put them into those things, there might be some animal rights people who will come and fight for them. And you're putting people in cages while they're innocent. Trial is going on, the person is sitting in a cage. And here you are, I mean, in a way, you're the judiciary, you can get away with it. But is that fair? So, I mean, if you are able to give them justice, if they want it through you, give it to them. Don't put anyone behind bars for 1 minute also. Who has the right to take away Anna's freedom? You are inefficient. How can you take away her freedom? So those are things that need to be questioned, and no one questions them because, again, the colonial system, you don't question the judiciary. That's the colonial powers institution. So I think those kind of things which stems from that whole colonial concept. So you don't even question the legislation. The fact that legislation in relation to mediation in the court system came up, I think by itself was the worst step that could have happened. And then the lawyers took over, and now it's a lawyer control thing in the US, which by itself goes against the concept of mediation totally. So I think that a lot of factors, I mean, needs to be, I mean, how do you change it also? And judiciary has enough say in matters. They would not let go of it because they're inefficient. And this is their way of getting some cases go out, not a problem. So I think there's lots that should happen, but can it happen? How do people lobby for it? First of all, I keep telling people in every country, just stop doing mediations for free. Just stop it. In the court system, they would want you to do it. Don't do it. If there are no mediators, how does mediation happen? And don't even think, don't be misled that if you are going to the courts and you're doing mediations, you will be recognized by lawyers and they will give you private work. They will not give you any private work. And this is an experience from a mediator in one of my symposia that I had, who spoke about his own experience. He said, I mean, of course, thought that lawyers would recognize me, so I offered my services for free in the courts. No private work came to me. I asked the lawyers, you've given your time for free, because finally the lawyers want to just control their fees. Why would they want to pay another person? They would rather get all the fees to themselves. So I think people should not be under the illusion that they will get any private work coming out of it. And again, he say that mediator spoke about how he goes to a particular, he was talking about the Beverly Hills Bar Association, and he goes there, and every year there's a totally different lot of people who come in as mediators. And he talks about how a lot comes in, they think they'll get private work, they don't get private work, they're doing it for free, they get disillusioned, move out, a new lot comes in, and that process goes on. So it's not good for the mediator. How do you take mediation forward if the mediators are disillusioned? So those are a lot of factors on the other end which are an issue. So I want it to be totally out of that system. I mean, yes, basic legislation, and that's the only thing happening. We should not even have to use the terminology private mediation. Mediation should be private. There should be no other mediation to compare with. There should be no court annexed mediation. Mediation should be private. It should be what people want to do. And that is where you have to develop the culture from the grassroots level, that they're exposed to it at the first instance, which is what that World Mediation Circle of mine, create mediation circles in schools, communities, colleges, all kinds of organizations. Let people experience it at that stage and take it as a process that they connect with. They connect with a mediator. They should identify those mediators themselves around them. And then once they connect with it, they experience it, benefit from it, they'll take it forward themselves. You don't need to do anything beyond that. You don't have to push anyone into it. Maybe I said too much, Anna. This is your session.
No, but I totally agree with what you're saying. Well, as a mediator, I love to listen, but I really like what you're saying, because I think if we start at the school level when they're young, and it's a cultural teaching that, hey, mediation is a way to resolve conflict. You know, you don't need to go litigate. You don't need to go to court. You don't have to have that stress. We can do it right now. You don't have to wait for a court date. You can do it right away. So I think education, awareness, since people are, you know, little, 6 years old, they can learn this. I think it is a big job for all of us as mediators to really educate our countries and say, you know what, you know, I speak about marriages on a platform on Sundays, and somebody from Chile sent me a message saying, you know, I would love to get divorced using a mediator. I would not like to go to litigation, but, you know, I don't know how to approach it. And somebody from Argentina. And so I contacted somebody from Argentina and from Chile, and they were able to meet with them. But people have no clue that they can actually use that service with a private mediator. So
that's
anyways.
why, Anna, you have to work with me to create these mediation circles. Let's create them in schools and everywhere. That's the whole idea being, it might be a small little circle, but at least those people who have that mindset, let them come together. At least they know that there are other people like us who think in the same way, that let's amicably resolve things, let's collaborate, let's just get those people together. By itself, one is, of course, disputes getting resolved. This group of people will actually contribute a lot to society when you can have people who can have objective discussions. You say, I mean, this conversations itself people are not having because they're polarized. I mean, there's not a negativity on the other end. So just to have people sitting together and just discussing things in an objective manner, that by itself, I think people are missing out on. So either it's social media, me against you kind of thing happening there, or in general in society, some people trying to create that divide, politicians trying to create the divide because that's how they rule. That's again a colonial system. I think maybe I talk about the colonial system too much, but that's what it is, divide and rule. So there has to be an alternative to that. And I feel those circles will be an alternative to that, which you will hear me saying advocacy, activism, politics on one side, and the mediation circles on the other side. So this is how I look at that, those circles to have a much larger role to play in communities, in society in general. And I mean, the global situation mirrors the local, and local mirrors the global. I think it's all goes together. So if you create that environment there, over time, you will see the changes. Maybe, I mean, let's hope changes happen, but you'll see that change because these are the people who grow up and be the politicians. They will be the people who would be in government. They will be in businesses. If they take that mindset there, the collaborative aspect of it, I think it can change things over years maybe, but that's the step.
I think maybe I am a little bit too optimistic, but now with social media, with the pandemic that makes us more aware of what's going around the world, I think we are in a good path to get it faster in the US than in 50 years.
Absolutely. So, Anna, so what would be your concluding remarks?
My concluding remarks would be that mediation is the future of disputes. It really is. And education on mediation should be our number one education and promotion, our number one goal as mediators, to help us and to get together as mediators to promote mediation around the world. And you know, I think you have several people coming from other countries, and I think you're doing a great job by bringing an awareness globally, not just in your place in India. So I think education, promoting, and telling people how wonderful it is and how good it is.
Well, look, when you say looking at it not locally but globally, I look at mediation itself as something which is beyond borders, actually beyond legislation itself. The whole idea being that you should be able to pick up anyone from anywhere in the world, and being online, much easier. Whoever you want, there should be no restriction on whom you can appoint as a mediator or want to bring in as a mediator. Well, it's your choice, someone you trust. And if two people trust someone, that's all that's required. So looking at it globally, so no borders, nothing, whoever you want. You do it the way you want to do it, the process. No one should be able to control that aspect of it. Do it
Mhm.
online, do it wherever. And after that, whatever settlement agreement you get into is enforceable wherever, whichever court you have to go to, if you have to go to. There should be no issue. It should not be that I got into this I was in Australia and I want to enforce it in the US. No, it should be able to enforce it anywhere. That's the global regime of mediation that I look at. With we have the Singapore Convention signed, of course, for international commercial disputes. But the good part about it is that that settlement agreement could have been signed anywhere in a country which is not a signatory to the convention also, but you can enforce it in a country which has ratified the convention. So, but this is for, say, like I said, commercial disputes. That doesn't matter. I think that should be the way mediation should be looked at everywhere. You should be able to, there is no concept of where you signed it. How does that matter? We could be sitting in say, maybe an airport terminal. We just met there and signed it there. How does it matter where you signed? So that should not matter. And once you've signed something, you've agreed to it, and that's the end of it. And then wherever you have to use it, use it. So I think the fact of legislating itself, for me, is an issue. And like I said, for those simple things that if you have to legislate for, that's all you need to legislate for. That settlement agreement or that mediation could have happened anywhere, but no court should bring in that mediator as a witness, or it should be without prejudice, and of course confidentiality, protect those things. So that's the way I look at it on a global level. So there should
Yeah,
be
and
no.
I think that you're hitting a really good point where, as a mediator, I can only divorce people in Utah because of the legislation. I cannot divorce somebody from Idaho or from New York, only from Utah. But you are bringing a point that is very good, and I like it, because a lot of people have asked me, could you mediate my dispute with my company? And I go, yeah, I could do that. And I am in Mexico. Could you do that? Yes, I can.
Exactly.
And I think that globalization of choosing whoever you want from another country to help you in your dispute, it's a wonderful thing that it shouldn't be regulated or legislated at all.
Absolutely. That's the way I want to put it out there, which is why this symposium, and then we'll take it forward in our discussion together when we do it. These are the things that we have to bring out. So Anna, thank you very much. Lots to discuss, lots to do, and work on the ground, lots of work on the ground. So
Yeah.
thank you very much.
Well, thank you for the invitation. It's been wonderful talking with you.
A pleasure speaking to you. And of course, we have lots of more conversations. So thank you.
Have a great